that you do that by this. Now, I'm not sure that that is really specific enough. On the countering that is that it does clearly say what Ms. DeLong says it does in the decree, 50%, whether vested or unvested. Now, I would not interpret that in any circumstance to have been going forward after divorce.
No, Your Honor, and it says as of the date this final decree is signed.
Okay. Okay.
Does it's not future benefit.
Okay. Now I've seen what he drafted, but not what you've drafted in his attached to his motion. So I don't. Does your language say that?
Yes, it does, Your Honor. In fact, the quadro that Mr. Osborne has presented to you is my quadro with one clause added to it.
Oh, okay. All right.
And if you remove that clause, then you have my quadro. He revised it and added the language that says the portion acquired during the marriage. Typically, drafting a decree, had that been the intention of the parties, we would have said accumulated between these dates or during the marriage or the community portion or some limiting language.
Right. But even if it didn't have limiting language, I would, unless you had specified it, I think the right answer is always to interpret it in light of the case law that outside of anything else, it's if, as, and when. It's the numerator is the number of months in the marriage. The denominator is the number of months in the plan when he retires. And so we don't have a question of that the, so we have a question of the numerator here. Did it start at the very beginning? Because as they're gonna need to determine a percentage at some point, right? Because that denominator is going to continue to grow, and so we're not talking about. We're not taking out of that. We're not saying it's 50-50 no matter what. Whenever he retires. So the question is, did he deliberately convey in the Rule 11 agreement and this decree some months before the marriage? Okay. And that really involves some sort of consideration, and maybe not necessarily a quid pro quo, but that's the way we think of it. Hey, I will horse trade you. You have a reimbursement claim. If you drop your reimbursement claim, I'll convey you this. You know, sometimes it's not your retirement account. Sometimes it's the china and, you know, and the lawnmower. But here, that's where that is. So now we know squarely what that argument, what the disagreement is. So let you have one more opportunity to tell me anything you don't think I know or that you want to emphasize, and then I'll try to make a ruling there. Mr. Osborne, you may begin.
Thank you, Honor. We did not realize there was a dispute on this issue until we sent the quadro back to Ms. DeLong. At all points during the mediation, we were contemplating dividing the community estate. And so if there was without getting into what was said and horse traded at the mediation, I can say unequivocally that Mr. Flippin never intended to deed over or convert his separate property when we were dividing up these assets. So in hindsight, it certainly would have been better for us to have specifically stated 50% of the community interest. But we did not realize that was an issue until Ms. DeLong noted that she was seeking those additional years. And it's about, I think, just over 5 years of time that he had worked before he was married into that account. And so we did not knowingly or intentionally want to convey his separate property to her. What we thought we were doing was conveying 50% of the community interest in that account.
Mr. Long?
Yes, Your Honor. The presumption arises always in a marriage that property is community. In this particular case, there was a great disparity in earning capacity between the parties and quite a few other factors to take into consideration. We very intentionally, in the mediated settlement agreement, did not put limiting language. And a party can certainly agree to give another party 75% of any portion of their retirement or whatever amount they want to give. It doesn't have to be 50-50 of any specific thing. In this particular case, we specifically did not include limiting language because of the duration of the marriage, because of disparity in earning capacity, other factors. And so we didn't put that limiting language. And without that limiting language in the mediated settlement agreement or in the decree, I mean, very clearly, we have total account balance in the decree. And that's just, of course, through the date of divorce. And that's what our quadro says. But that's what we negotiated for. That's what we agreed to.
Mr. Osborne, how many extra months are we talking about?
I think about 63.
So a significant amount.
Yes, Your Honor, and Section 3.001 of the Texas Family Code defines what separate property. I can just state unequivocally that we never intentionally wanted to convert that separate property interest when we negotiated this agreement.
Similarly, there is no confirmation anywhere in the decree or in the mediated settlement agreement of any separate property. It has not been confirmed, and that would need to happen in order to confirm some portion of retirement or any other property as Mr. Flippin's separate property, as we did with the house. And that wasn't done here in regard to the retirement.
Okay, so let me start with the rules that will apply. I want to be clear so that if either of you feel like you need to take it on a different direction, either by further motion in this court or on appeal, I want to be clear so that anybody who would review this other than myself, I'll know. But if anybody else does, they'll know clearly what I'm ruling. One is, this is determining this matter from the four corners of the document, and that document is the divorce decree. The divorce decree would supersede the Rule 11 agreement or the mediated settlement agreement. However, the mediated settlement agreement can be looked to help interpret the language of the decree, as well as the original petition for divorce. Ms. DeLong is correct that all property on hand at the dissolution of marriage is presumed to be community, and then therefore it was up to Mr. Osborne to establish what is separate property. I don't believe that, and I'm ruling that this language in the decree that is based on the Rule 11 agreement is sufficient to inform a court that there was a conveyance of separate property. So the question is, at the time of entering the decree, was this separate property or was this property still presumed to be community? In light of the fact that there is no request to deviate, and there were findings with regard to the beginning of the marriage and the end of the marriage, that he was not divested as of a date prior to the date specified in the original petition for divorce, that the parties were married on or about August 7th, 2006. And so the court will rule that any months before August 7, 2006, remained his separate property and should not be included in the quadro. if, now that I have made that ruling, Mr. Osborne, does your language attach to your quadro or your motion to enter? Is that the correct language?
That's exactly what it says, Your Honor.
Okay, Ms. DeLong, without requiring you to agree to my ruling, is that form of that order correct?
It's the order I drafted. That is the language we accept to and disagree with is the language that would create a separate property interest that is nowhere otherwise referenced in the decree or in the mediated settlement agreement.
Okay, and so I need it actually to be separate from the motion, Mr. Osborne, so that, because, you know, it's filed in and of the record as an attachment. So can you e-file that?
Yes, we'll submit it as a proposed order, just the order.
Okay, Ms. DeLong, have I defined my ruling sufficiently for you to be able to work with if you dispute it in another arena?
I'm not sure, Your Honor, that I understand in terms of what in the decree would set aside or confirm any separate property interest.
Okay, what I'm ruling is the absence of language that it was clear from the pleadings in the case and not disputed when the marriage started, and that the language used did not, in my opinion, did not clearly take this out of the interpretations of these agreements of quadros, retirement plans of an if, as, and when distribution, and that it needed to be clear, more clear than it was, that he was trading some interest for giving up his separate property, which was any part of that plan prior to the date of the marriage.
Then, Your Honor, if I could ask a question, are you then saying that based on the pleadings, a presumption arose that property acquired prior to the marriage was separate?
No, I'm not saying that there is any presumption. I'm saying that it was pled that the marriage began at a certain time. That was not disputed, and that, given nothing else, that established the framework for the beginning of the marriage. And that anything before that is established as his earnings there were his separate property.
But, Your Honor, then there's nothing specifically in the decree that confirms separate property. I think I understand what you're saying.
I'm pausing for y'all's benefit, so, and looking back at this decree. Okay, Mr. Long, let me ask you a question, and let me withdraw my ruling for just a second. The decree does not state when they were married, and that would be some extraneous evidence to then apply. We have an original petition for divorce. And that, Mr. Osborne, was filed by you. Is that correct?
Yes, we had to file a motion to sign to get that entered.
Okay. No, I'm talking about the original petition you filed.
Oh, yes, Your Honor, correct.
And then there's a counter petition for divorce. And Mr. Long, you filed that.
Yes, Your Honor.
And it states the same date. Both of you have filed pleadings in this case saying that August 7th, 2006 was the beginning of the marriage. And
Yes, Your Honor.
The court can,
Right.
the court can consider that this is an undisputed fact upon which the divorce was granted. So therefore, by admission of both parties, August 7, 2006 was the beginning, that any earnings thereafter are community property. And it's clear from the decree, and in interpreting it, looking at the Rule 11 agreement, which parties have asked me to enter into, that there is no specific exchange. And the court just doesn't have jurisdiction without an express exchange. And the court is ruling there was no express exchange. And therefore, the court doesn't have jurisdiction to divest him of earnings prior to the date that both parties stipulated in their pleadings. And I'm going to use the word stipulate. I'm going to withdraw the word stipulate. You did not make an express stipulation, but it was undisputed because both of you pled that date for the beginning of the marriage. And to do otherwise without his express conveyance of that separate property, and that express conveyance, and to the extent that it differentiates from that it doesn't, that it states something different in the decree of just awarding 50-50, that it should not be interpreted that way. It would fail without an express conveyance. I understand the argument that in other things, you would put in limiting language or not, but that may be a practice that's done. But to convey your separate property requires an express conveyance. And I don't believe this rises to that level. And so therefore, in interpreting the decree, I would interpret it because both parties pled the beginning of the marriage, that it is undisputed when the marriage began. And therefore, the court would not have jurisdiction outside of an express conveyance to divest him of his separate property. And so, Mr. Osborne, I will grant your motion, and if you will e-file that. And I hope that I've been clear on my rule.
Yes, Your Honor. May we be excused?
Yes, thank you. The parties are excused.
Thank you, Your Honor.